I hope the break was sufficient and that we can go on. Sorry for not letting it be a longer one, but we're already a little behind schedule, and this session will be longer than planned, since if you remember, we had one participant who couldn't present when it was due on Thursday, and he will be presenting now with us, Dmitry Dolgikh. So we will have a slightly longer session than usual. So this is our 7th session, Changes in Contemporary History, but we will be starting with a paper that does not concern contemporary but medieval history. So that is Dmitry Dolgikh's paper, Relations Between Law and Religion on the Example of Canon Law in Medieval Europe. So that will present a historical basis for our further papers, a number of which do concern the Catholic Church in contemporary history. So, Dmitry, are you there?
I'm here.
Okay. I can hear you. I can't see you yet.
Yes. Will I start?
Can you turn your camera on? It would be better if we could see you. But if you can't, of course, it's not mandatory.
Okay. So, my title name is Relations of Law and Religion, an example of canon law in Middle Europe. And the two things common to all medieval social groups united in European society were religion and law. These two components created and state and cemented society, formed European civilization and culture. And at the same time, they were very close in content and target orientation, and therefore closely related. These components did not contracted each other and were able to become a common foundation for the cultural and historical phenomenon that we call Europe. And this similarity lies primarily in the universality. Perhaps it's the main quality of both the Christian religion and the Roman law. By supporting and enriching each other, they were able to link together the peoples inhabiting a vast expanse. The Christian religion operated in the vastness of the Roman Empire at the time when this civilization lost the most important foundation without which it eventually collapsed. It was the ideological justification. And Roman canon law is an integral part of medieval European civilization. Canon law arises together with the Christian Church, but it does not receive registration immediately. During the 6th-10th centuries, the general theological doctrine of the Christian Church was formed, and as well as the order of services and the norms of general church discipline. During this period, the canons, norms, and rules are identified with the decisions of councils and synods. For example, these assemblies of bishops, with the decrees and decisions of individuals, bishops, as well as with the text on punishment in the Bible. In all time, there was an important internal church reform organized by Pope Gregory VII, which resulted in the development of a special essential system of law called the New Law, as well as the New Catholic Law. In the way canon law is a law contained is essential canons, laws published by the religion authority and sanctioned by the secular authority. The moment of the birth of canon law can be considered by publication of the collection of rules of the Council of Nicaea in 322 under tolerant Emperor Constantine, the time of the highest flowering of canon law in the Middle Ages, although the right exists within limited limits even today. The first condition of canon law were provide collection of canons. These include a collection of canons and a collection of text about 74 titles, and also collection of all norms, ifs of churches, who for the first time in the 9th century sets our entry canon law. And at the same time, Gregory VII declares the authority of the Pope to create new laws according to the needs of the time. And these papal laws were called decretals and were no longer perceived as a complementary and clarifying regulations, but as completely new ones. So a separate area of regulation was, of course, the author of Roman Church, and a special category of regulation extend to the relationship between the ecclesiastical and secular authorities. General crimes also often fell within the scope of essential jurisdiction. So, in addition, in the Middle Age, all legal relationships in the marriage and family sphere were regulated by canon law, of course. These include the establishment of the age of marriage, the order of marriage, the prohibition of divorce, the property relation of the spouses, the determination of obstacles to marriage, and the determination of the legality of the birth of children, and the dissolution of the marriage bonds. And I think my abstract is ends, and thank you for attention, and I can answer some question. Thank you.
Okay, thank you, Dmitry, and thank you for sticking very close to the time limit. So we proceed with the rest of the session as planned in the program. Our next presenter is Sofia Lekic from our University of Belgrade Faculty of Law, but also the Faculty of Political Sciences, and her subject is Contemporary Roman Catholic Doctrine, Only a Mild Influence on Modern Law or a Legal System in its Own Right.
I'm going to start sharing my presentation now, if that works. Do you see it?
It's still loading. Let's wait, it might take a minute. Yes, we can see it.
Right. So, first of all, I'm honored to be on this conference, and I would like to talk today about the contemporary Roman Catholic doctrine in a somewhat theoretical way. I'm gonna start researching whether the doctrine can be considered a legal system, or is it only an influence on modern law. Today we live in a world where the secular part of life is separated from the sacred one. So for people, the first impression is always religion. That's for people who want it and not for others who don't, and it has nothing to do with law. It's often even the two conceptions are placed as opposites. Religion is something imprecise, moral, and not concrete, and the law as something rigid and precise. However, if we look closely at the Roman Catholic doctrine specifically, and some other religions as well, we might see that there are certain similarities between the concept of law and legal systems and the rules of certain religious doctrines. I am going to try and see whether those similarities are enough for us to consider them a somewhat atypical legal systems, or is this a purely coincidental similarity that has no further impact on our understanding of these concepts. At the beginning of my research, I had to face three challenges. One of them was the specification of the legal system concept in general. As we all know, jurisprudence is a highly imprecise discipline, not for the lack of trying of various theories to make it precise, but precisely because of the topic of its analysis. Therefore, just like we don't know what is the law, we can't know precisely what a legal system is. Various theorists have tried to give an answer to this, and we have, separated these into three categories of definitions. The first category I separated is those one-sentence definitions. Those are the definitions that try to give an absolutely complete definition to a certain concept. Saying a legal system is that, or every legal system has that, and that. So they try to leave no further in unknown parts, but aim to be complete. The second type of definitions I drew out are the definitions on the constituted elements of a legal system. These definitions try to list out the elements that are specific to the most legal system known to humankind, but do not presume to be complete, but say, yes, these are the elements that I consider the most important, but there are other things that are not mentioned. And the third category is not a definition per se, it is more of a clarification and a source of defining a legal system. Those are the divisions between different types of legal systems. I used all three types of definitions in my research, as well as some definitions of law relevant to the concept of a legal system, in my opinion. For example, one-sentence definitions are very highly present in natural sciences. The cell is a functional unit of every organism, or the gravitation is a force of a body pressing onto the surface, and they are resolute. You don't have to think, oh, there are some borderline cases. Is this a cell or is it not one? It's over. You said it, and there is no further dilemma. However, when we're talking about legal systems, we have various attempts at defining legal systems in one sentence, relatively speaking. Perhaps some of the more interesting ones are the definition given by Hans Kelsen, that a legal system is a system of legal norms which all are connected to one basic norm and draw their validity and authority from it. Also, Joseph Raz, it's not really one sentence, but says that every legal system has norms pertaining to the use of force when in situations where it is prohibited, and in other situations where it is permitted or even encouraged. Some other definitions that I stumbled upon in my research are those who say that the legal system is an all-encompassing high system of norms in one society or state. The definition said state, but we'll get to it later why I changed it to a society. Also, definitions that say that the legal system is a logically organized whole of non-contradictory general legal norms grouped together and interdependent. And there are definitions that say that the legal system is a systemized whole of positive legal norms. Some of the aspects of these definitions I used in my compilation of various elements of legal system, which I will use in my further research, and others I omitted for various reasons. Some of them I considered irrelevant to the topic, inapplicable, better said, and others were somewhat obvious. If you say that a legal system has legal norms, that is a circle. If it is a legal system, the norms are legal. If the norms aren't legal, the system isn't legal. So that is not something which can be proven in an analysis. The definitions which list various elements of legal systems are somewhat more precise, and perhaps the most important one is the one given by Hart, who gave us 5 different types of norms and authorities which must exist for a legal system to be valid, and also some definitions which have criteria concerning the establishment and abolishment of laws, as well as the characteristics of legal systems. Lastly, the divisions between different types of legal systems are not a definition, but they can help us further examine whether a certain system can be considered legal or not. If we have a structure which can be applied to these divisions, it is another argument in favor of the possibility of that system being a legal system. The divisions I chose are the ones given by Hans Kelsen again, between moral norms and norms valid through the process of their creation as the basis of a legal system, and some of the definitions given by Dmitry Dolgikh, where he separated legal systems which are dependent on religion or not, which are traditional or modern, type of sources used in them, etc. Definitions of law relevant to the concept of a legal system say, perhaps, for example, that a good action agrees with the law precisely because the action is good precisely because of its agreement to the law, not because of some higher moral value or something like that. And there are certain theories which focus on the correlation between the legal norms and their recognition by courts of justice. Now I'm going to move on to the compilation I made of these definitions which I mentioned, and I have 6 criteria in my quasi-definition of a legal system. Why quasi-definition? Because it doesn't define really, it's just a list of some things I considered important and typical for legal systems. There are 6 various categories of the criteria I used. The first are the nature of the norms and their interrelations. We'll get to the more detailed show of that later. The second is the validity and authority origins of the system. Next, the elements of a legal system, characteristics, classifications of them, and the role of the courts of justice and the motive in determining legal guilt. Now that the concept of a legal system has been, let's say, defined relatively, the other problem or a phase of research I had to undergo was the definition of the part of Roman Catholic doctrine I would research. As we all know, Roman Catholic doctrine is extremely old, 2,000 years and over that. So I decided to focus on one chronological period in its history, because otherwise this research would be too broad and impossible to conduct. I chose the contemporary Roman Catholic doctrine for various reasons. One of them is the fact that I am most familiar with that period of its development, and the other is the specificness of this chronological period in comparison to other ones. The border in chronology I chose was the First Vatican Council held in 1869-1870. This was a council held after many years of no ecumenical councils in the Roman Catholic Church, and it changed quite a lot of principles of the Roman Catholic doctrine. First of all, it established the primacy of the Bishop of Rome in the organization of the church, which was up until then only a customary belief, but not enforced by a formal document. Also, even more important was the establishment of the infallibility of the Pope ex cathedra, which meant that whatever the Pope said when talking about the doctrine was taken as the law of God. Also, why I chose this border is the fact that it gave me a period of 150 years, roughly speaking, which is a long enough period to have some objectivity of the analysis, because if it were shorter, we wouldn't be sure whether the effects are lasting or only temporary. With this length of a period, it has more probability of being an objective analysis. So the further centralization of the church by the primacy of the Bishop of Rome and the changes in the doctrine made by various declarations the Pope gave in the subsequent years are what separates this chronological period of the Roman Catholic doctrine from the other ones, and the reason why I chose this for my research. Now, after we established these starting conceptions, I would like to switch on to the definition and try to go through this list. I wouldn't go too much into detail, but in short, the parts of it I consider extremely strong in favor of the legal system nature of the doctrine, and some parts which I consider weak links and perhaps even breaking points in the conclusion. The first element of my point definition is the nature of the norms and their interrelations. We have 4 sub-parts in this criterion. It is the fact that the norms have to be legal, positive, and non-contradictory. I examined this, and this is not a very hard criterion to prove because the norms are positive. We're talking about the contemporary doctrine, which is still in use by a very large number of people. The norms are also not contradictory, not because I really researched every single norm and compared it to others. It is too big a job to do. However, the number of legal sources in the Roman Catholic doctrine is quite small compared to other legal systems. And the principles of later norms derogating the earlier ones is still strong, so there is not too much space for any contradiction. The criterion of the legality of norms I already mentioned, it cannot be proven without saying whether a system is legal or not, so we're going to skip over that part and get to it in the conclusion once again. Also, the interdependence of norms is an important factor. The interdependence in general cannot exist, for example, between any 2 norms in a legal system. However, all the norms are somehow connected to some of the other norms. We have that also in doctrine because of all the nature of the doctrine, where all the norms are connected either to the Bible text or to some of the decisions made by the ecumenical councils or the Pope after the Vatican First Council. Here we get to the criterion of the highest normative system in a society. Originally, this definition said the highest normative system in a state. However, there are various theoreticians who say that the legal system can exist without a state, but with another institution which has a very strong social status. So I'm going to change this state into a society or the institution of the Roman Catholic Church for the purposes of this research, of course. And I think this is important criterion because it could be said that yes, a person can be a Roman Catholic, however, they have to stick to the state law, and that is true. However, the Roman Catholic doctrine very rarely or never gets into conflict with the state law. If anything, it is more strict, so a person who obeys the Roman Catholic, let's say, legal system, if it is a legal system, cannot be breaking the state law, so it can be the highest normative system without a person being a criminal. The determined range of application is a criterion I added because I think that every legal system has to be determined for whom it is in use, because, for example, the legal system of Germany has no relevance to a person in Russia, etc. And in this, we have one of the canons in the Code of Canon Law, the first one. The canons of this code regard only the Latin Church, which means that this system explicitly said which people need to obey the laws and for whom the system is completely irrelevant. Generally, this first criterion seems to be to have no problems, so we're going to move to the next one, the validity and authority origins of the legal system. Here we have the already mentioned Hans Kelsen, and some of the concepts given by Solomon, who said that all norms can be traced back to a willing thinking being. The point of this criterion is the fact that, however a strong legal system may be, it has to have a certain principle or a basic norm or anything which gives it the authority, because we can make the most rigorous laws in the whole world, and if there is no compulsion on the people to obey it, it is just a word on the paper. However, the common source of the validity of all norms must be one basic norm or a set of certain self-existent principles, which are not regulated by the law, but by some other social beliefs or something similar. Here we have, again, one of the articles in the Catechism of the Catholic Church, number 157, which says that faith is certain. It is more certain than, just a second, I'm sorry. It is more certain than anything in the human knowledge, because it is founded on the word of God, who cannot lie. Now, for people who don't believe in the Roman Catholic doctrine, this doesn't seem to be any proof or any reason to obey. But as we already said, these rules only affect people who are believers of this doctrine. So for them, this declaration is enough to be a valid reason to obey all the laws. Also, one of the declarations given on the First Vatican Council, Dei Filius, by the then Pope Pius IX, is that we do not have faith because of the percepting of the inner truth of things in the light of natural reason, but rather because of the authority of God who reveals them, who can neither be deceived nor deceived. Once again, what is postulated is the fact that people as humans, as mortals, cannot be the ones to make the law, but must obey the law of God, which is another reason for obeying. We have the similar thing said in the Romans 13:1, for there is no power but of God, the powers that be are ordained of God. And in St. Augustine, from him originates every rule. All these sentences, given some in the doctrine, some by the people who examine that doctrine quite closely, like St. Augustine, show us that in the world of people who believe in the doctrine, this is enough reason for the rules to be the highest normative system and to be obeyed. Once again, this second criterion is not problematic, but things are going to change quite soon in the elements of the legal system. Here we have 6 elements of the legal system. The first 5 were given by H.L.A. Hart, and the 6th one is given by Solomon. Rules prohibiting or demanding certain types of behavior are obvious. Of course, every system of norms, be it legal or not, prohibits or demands certain types of behavior. Otherwise, there would be no need for norms at all. So that is not a problematic thing. Rules demanding compensations for harm done to others is a somewhat more difficult question, because although the Roman Catholic doctrine, as all Christian doctrines, supposes that people should be considerate to others, not harm anyone, apologize for their mistakes, and all that. The question is whether the system has a specific norm about it. And when I first started researching this topic, I thought that it would be a problem. However, there is an article in the Catechism of the Catholic Church, number 104,059, which says that many sins wrong our neighbor, and we must do what is possible in order to repair the harm, return stolen goods, restore the reputation of someone slandered, pay compensation for injuries, etc. While in the broader context of this catechism, this article is not really focused upon, but rather an introduction to other parts of the doctrine. It is irrefutable that at least in some part the doctrine has some norms which say that people must compensate for their wrongs. So this issue is also solved. However, the rules specifying what has to be done to make wills, contracts, or arrangements which confer rights and create obligation is, in my humble opinion, the most complex element of the whole definition and the breaking point of this research, whether the Roman Catholic doctrine is a legal system or not. Now, I'm going to run the risk of being labeled a perfect lawyer in the not so positive way, but by sticking to the syntax of this sentence and saying that make wills, contracts, or arrangements means that only one of the elements must be fulfilled. That way, if we say that contracts, for example, are enough, we can say that the contract of marriage is quite detailed in the doctrine, both in the Catechism of the Catholic Church and in the Bible. Marriage normally takes place during Holy Mass. The parties to marriage covenant are a baptized man and woman, free to contract, etc. The consent must be an act of the will. So the whole institution of marriage, I'm not going to read all these articles, it's all the words. However, the concept of marriage is quite detailed in the doctrine. Other contracts or wills, arrangements, obligations, etc. are not so detailed in doctrine for a specific reason. One of them is that in the times when the doctrine started existing, there was no reason for the regulation of such things. People lived in family unions. There was no reason to decide who would inherit what, etc. So back then, no other legal systems had, not no other, but some other legal system also didn't have such norms. In the contemporary doctrine, we cannot say that that would be the reason. However, the doctrine still says that people must be honest and fair to each other and regard every single human being as their brother or sisters. So that might be some of the explanation behind the lack of these norms. However, the fact remains that the contract law and the Roman Catholic doctrine is quite underdeveloped, which might be a problem in our analysis. Luke 6, 34-35 touches on the subject of lending things. And if you lend to them of whom ye hope to receive, what thank have ye? For sinners also lend to sinners to receive as much again. This verse in the Bible was often taken for a proof that Christians should not lend things, but rather give them to people who need them, and even more so that interest rates shouldn't exist between Christian people. We already had one paper in this conference talking about that, so I'm not going to further elaborate. However, this is also just an indicator that the Roman Catholic doctrine did not consider it important to regulate the contract law, but still the norms do not exist in the broad, narrow sense of the word. The next element of the legal system are the courts who would determine the laws, the situations of their breaking, and the punishments. Now, of course, the first association to this element is the final judgment court, once people are dead and they are judged by Jesus. However, not only that exists, that is widely known, but the Roman Catholic Church has certain tribunal or papal courts, which we will talk about more later when we start talking about the institutions. I'm sorry, I'm going to rush it a little bit. So to wrap things up, I think that the most of the problems with the Roman Catholic doctrine is the lack of contract and obligational law, as well as the fact that there is no state which would be the carrier of this legal system. However, I think that enough of these elements were fulfilled for us to consider it a typical legal system, because this definition is a prototype one. Not every thing has to be fulfilled in order for us to consider the legal system a legal system. So my overall opinion is that the Roman Catholic doctrine in the contemporary time can be considered a legal system, but with some reservations, especially about the existence of obligational rules and the recognition of this system as the supreme one in the society. I'm sorry for going over the time limit, and thank you for your time. I'm happy to answer any questions you might have, suggestions how to improve this research, and comments.
Thank you very much, Sophia. Sorry for reminding you, but just so everyone would have enough time for their presentations.
Sure.
Our next speaker is Antoni Cypriański from the University of Warsaw Faculty of Law and Administration, and his subject is the influence of religion on private law, example of matrimonial law in the Second Polish Republic, 1918 to 1939.
Hello, can you hear me and can you see me?
We can hear you, and now we can see you as well.
Okay, I will try to share my presentation.
Go ahead.
Give me a moment, please. No, can you see it?
Yes.
Okay, so I think we can begin with the presentation. 1 second, please. Okay, so thank you once more. My name is Antoni Cypriański. I study law.
I'm sorry, Antoni, just one thing. There's a drastic difference in volume when you're closer and when you're further away from the microphone, so please stay closer because it's
better now?
Yes, much better. Thank you.
Okay, I'm sorry. So my name, as I said before, is Antoni Cypriański. I study law on the University of Warsaw in Poland, Faculty of Law and Administration. I'm on the 3rd year. And first of all, I would like to thank, I think for the 3rd time, but once more, to the organizers for the possibility of deliver this short presentation, which is entitled "The Influence of Religion of Private Law: Example of Matrimonial Law in the Second Polish Republic." Let us move to the presentation plan. I will start with a brief introduction into history, just to know the whole context. Then I will move on to some basic information about Second Polish Republic. Point 3 is presenting a situation of private law after regaining by Poland its independence. Then I will present the most important facts about marriage regulations in every codification. And last but not least, will the conclusion to be presented. Okay, so in the year of 1795, Poland ceases to exist, being divided by 3 neighbor states: Kingdom of Russia, Austrian Empire, and Russian Empire. And after 123 years of captivity, after the First World War, Poland manages to return to the map of Europe and regains its independence. So the Second Polish Republic is born. On the right, you can see the borders of this state, and just some basic information. It lasted from the end of the First World War, so 1918, to the year of 1939, when it was invaded by Nazi Germany. The capital city was in Warsaw, and speaking of population, it was around, let's say, 34.5 million. So as you can, as presented on the right, you can see how the former partitions look like. On the red color, we can see a German partition, green color Russian partition, and yellow color Austrian partition. It's very important because on the territory of each of former partitions, private law was regulated by other codification, and so and such a legal order was adopted by the Second Polish Republic. So in the one state there were like 5 different legal systems. So in the western part of the country, in former Germany, in order was Bürgerliches Gesetzbuch in former Russia area, Napoleonic Code with Polish modifications from 1825, when the Kingdom of Poland was part of Russian Empire, and Russian Tsar was had also title of Polish king, and digest of laws of the Russian Empire, and on the yellow color in the Austrian partition, in order were Allgemeines Bürgerliches Gesetzbuch, so ABGB, and on some really tiny parts of Galicia, Hungarian custom law. For the purposes of this presentation, and due to the time limitations, I will focus on only 3 of them: Prussian BGB, Austrian ABGB, and modified and Napoleonic Code with some Polish modifications. So to begin with, Napoleonic Code, which was in order in part of the Russian partition. The marriage law in force in the Kingdom of Poland from 1836, because under this regulation, authorities issued Matrimonial Law Act from 1836, which was about to regulate matrimonial issues. So it was strictly denominational. Therefore, marriage could only be contracted according to each church regulations, and with the completion of religious ceremonies. Every canon law became the source of matrimonial civil law. Therefore, in the event of differences between religious law and the civil law, the first one, the religious law, was to be applied. So divorces were conducted only on religious basis, which practically eliminated possibility of divorce to some faiths, for example, for Catholics, because Catholic Church doesn't recognize any divorces, so it was impossible for Catholics to conduct a legal divorce. In the main of Austrian partition, where the ABGB was enforced, the Austrian marriage law took into account the provisions of religion supposes. However, they did it in a different way than it was in the Russian because yes, the basic form was religious marriage, but the principles of canon law were enforced as provisions of civil law. And the main form, however, the main form of marriage in Austrian law was still a church form. The judiciary in matrimonial matters when transferred to the state courts. So they decided about any divorces and things like that. And the situation was completely different in the former German partition when the BGB was to apply. The institution of marriage was a state institution, a secular one. The German code only formulated a civil marriage for all of religions. There were no obstacles arising from religious reasons to marry, because it regulated the principles of matrimonial law equally for all of faiths. The marriage was conducted before a secular state official. Divorces were also secular, and jurisdiction over matrimonial matters were reserved for civil courts. Although, of course, religious marriage was possible, however, it did not have any significant matter for private law. So, as we can see, religion is very possible to affect private. It's possible to affect private law very strongly, very much. On example of the Second Polish Republic, we could see how different this impact could be. What is interesting in the fact that under one state, five different legal systems, sometimes opposite to each other, were enforced. And here are sources I used to prepare for this paper. Thank you very much for your attention.
Thank you, Anthony, for this interesting presentation. I'm sure there will be questions in the discussion. And we move on now to George Timotievich from our Faculty of Law in Belgrade with his paper, Legislation and Religion in the Kingdom of Serbs, Croats, and Slovenians and the Kingdom of Yugoslavia. George, go ahead. Your microphone is still off.
Can you hear me now?
Yes.
Okay. Thank you, Professor. I will be speaking today about legislation and religion in the Kingdom of Serbs, Croats, and Slovenians and Kingdom of Yugoslavia. Now, as a bit of an introduction, so to say, churches and religious communities retain the same legal position as in the countries that became part of the new state from the creation of Kingdom of Serbs, Croats, and Slovenians on December 1st, 1918, until the adoption of the first constitution on June 28, 1921, also known as the Vidovdan Constitution. Now, the existence of numerous nations and different religions on the territory covered by the state of South Slavs decisively contributed to Regent Alexander to issue a proclamation on January 6, 1919, guaranteeing equality of all religions in the kingdom and confirming the elimination of the privileged position and the state status of the Orthodox Church in Serbia and Montenegro, which was agreed by the Corfu Declaration. Now, the complex interethnic and interconfessional situation in the new state influenced the Allied forces to raise the issue of protection of minority communities during the peace negotiations, and by the provisional law on May 10, 1920, on the treaty between the Allied powers and the Kingdom of Serbs, Croats and Slovenians, which was signed on September 10, 1919, the new state committed itself to the right of all inhabitants to freely perform public and private rights of any religion. And according to the decree published on July 31, 1919, the Ministry of Religion exercised the supreme supervisory and highest administrative authority over all religious affairs. But the complete administrative competence in the last instance was given to the Ministry of Religion only in Serbia and Montenegro, so the other countries were excluded. And the Corfu Declaration and the proclamation of Regent Alexander and the Treaty of Saint-Germain indicated the possibility for the Constituent Assembly to accept the principle of separation of church and state. But the Constitution of June 28, 1921 abandoned the system of state churches but did not implement the consistent principle of the separation of religious communities from the state. Now, religious communities have been given the status of public institutions with a special position in the state and special privileges and the authority to perform public law affairs, but on behalf of the state and under the supreme supervision of the state. Now, with the constitutions and similar solutions were retained by the so-called Enacted Constitution, which was given by King Alexander of September 31st, 1931, and this constitution divides the adopted and recognized religious communities. Now, the position of the adopted was given to all religious communities that were legally recognized in any part that became part of the kingdom, but there are significant differences between individual authors in determining the number of adopted and recognized religious communities in the Kingdom of Yugoslavia. One group of authors believes that the Serbian Orthodox Church, Catholic Church with the Greek Catholic Church, the Evangelical Church, Reformed Baptist, Methodist, and Nazarene Church, and Jewish Church had that status, but according to the second position, only the Serbian Orthodox Church, Catholic Church, Evangelical, Islamic, and Moses Church were adopted and recognized, and other religious communities were banned and their members prosecuted. And now, there were numerous laws adopted in the new state. The most important one for Serbia is law on the Serbian Orthodox Church, and this law stipulates that the Serbian Orthodox Church is autocephalous with the dignity of a patriarchate, and religious teaching is professed publicly, church freely performs worship services, and independently regulates church religious affairs. Now, independent management of church property, funds, and endowments is provided with the prescribed restriction of performance in accordance with the law, the church constitution, and under the supreme supervision of the state. The control of revenues and expenditures will be performed by Serbian Orthodox Church according to its own accounting, regulated by a special decree, and the supreme supervision over all revenues and expenditures of the church will be performed by the main control. Now, the church as a whole, including its constituent parts and institution, has the status of a legal entity and the ability to acquire and dispose movable and immovable property, but property, endowment, and fund affairs are performed by the episcopal authority in communion with the clergy and the people through self-governing bodies, which will be more regulated in more detail by the church constitution. Now, church criminal acts and punishments are set also to be defined by the church constitution, and the church is represented before the state by the patriarch or his deputy, but the procedure for the election of the patriarch will be determined by special law and provided by the church constitution, and also the election of patriarch and bishop is said to be confirmed by the king by decree on the proposal of the minister of justice. And now church needs are financed by revenues from church goods and funds from the state fee and the church taxes. And transitional and final orders of this law regulate the status of church institutions, authorities, and persons who move from the state to the budget of the Serbian Orthodox Church. And the Church Constitution is passed by the Holy Synod of Bishops and proposed to the Minister of Justice, who forwards it to the King for legalization. Now, the organization of the Serbian Church provided by the law and the Church Constitution must be established within the 2 years from the adoption of this law. And besides the law on Serbian Orthodox Church, there was also law on the Islamic religious community from the Kingdom of Yugoslavia of 1930. According to it, all Muslims form one independent religious community and are headed by the Rais al-Ulema as the supreme leader. And the Islamic religious community publicly professes and teaches its religion and freely performs religious rites. And numerous bodies of the Islamic religious community were established. The Jamaat Majlis, headed by the Jamaat Imam, Waqf Ma'arif, District Commission with the Sharia judges chairman, the Mufti's offices, the Ulema Majlis, and Waqf Ma'arif Council in Sarajevo and Skopje. So the composition of the mentioned bodies, their scope of work and competencies will be provided by the Constitution of the Islamic religious community. And the procedure for the election of Rais al-Ulema, members of the Ulema Majlis and Muftis will be prescribed by a special law, but all of those are appointed by the king and by his decree. The Islamic community independently managed and freely disposed of religious property and endowments within the limits of the law and its own constitution, and of course under the supreme supervision of the state. Now, the Islamic religious community controls revenues and expenditures independently, so do other religions, through its competent authorities, which will be prescribed again by a decree and under supervision of the main control. And the Islamic religious community is represented before the state by Rais al-Ulema or his deputy. And now the Islamic religious community meets its material needs with revenues from religious and Waqf Ma'arif goods and funds, and also the religious taxes and voluntary contributions. Now, the King's decree at the proposal of the Minister of Justice in agreement with the President of the Council of Ministers, and by the way, Minister of Justice and the whole Council of Ministers was elected by the King. They will appoint the first Rais al-Ulema in Belgrade, 4 members of Ulema Majlis based in Sarajevo, and 4 members of the Ulema Majlis based in Skopje, as well as 9 Muftis. And the constitution of the Islamic religious community will be adopted at a joint session, which will be chaired by the Rais al-Ulema. Now, the law on evangelical Christian churches and on the Reformed Christian Church in the Kingdom of Yugoslavia. According to this law, members of the Reformed religion, also known as Calvinists, form a special Reformed Christian church in the kingdom, and also the Slovak and German evangelical churches may organize an alliance to promote common church interests. The evangelical and Reformed churches have full freedom of public confession of faith and religious rights in the church. Autonomous bodies, authorities, and institutions and their organization will be provided by church constitutions. Churches independently regulate religious education, charitable and other affairs, and manage property within the limits of the state laws, and of course under the supreme supervision of the state. Now, churches and their autonomous bodies have the status of a legal entity and the possibility of acquiring and using movable and immovable property in accordance with the constitutions, and within the limits of the law, the material resources needed by autonomous bodies to achieve the planned goals are covered by revenues from their property, church taxes, and offerings. Also, members of these churches are obliged to pay all duties and surcharges to cover the needs of the competent autonomous bodies and institutions, which was unusual. An obligation towards churches should also be fulfilled by believers who have property in a certain territory or are engaged in trade and other affairs. So the evangelical church was also relied on believers. which was different from the other ones, and correspondence with state authorities, as well as written communication with other churches in the state, will be done exclusively in the state language, and church legislation is said to be performed by the synod of each church, and the church constitution envisages the manner of electing the supreme spiritual leaders. Those are bishop and supreme senior, and the election of supreme spiritual leaders is confirmed by a king by decree on the proposal of a minister of justice, and priests must be fluent in the language spoken by members of church community. And churches are obliged to adopt constitutions on the entire organization at synods within 2 years, in accordance with the regulations of the law, and the Minister of Justice is authorized to prescribe provisions for the enforcement of this law. But besides this law, there was also law on the religious community of Jews in the Kingdom of Yugoslavia. So the new regulations basically covered all the existing religions. And the religious community of Jews was formed by all members of the Jewish religion who lived in the Kingdom of Yugoslavia, and they were guaranteed full freedom of public religion organized by religious communities, whose task is to take care of religious and cultural needs of the membership. Now, the Minister of Justice approves the rules of the association and the alliance, as well as individual municipalities. Jewish religious communities and their federation, for example, the association, are self-governing bodies, and they independently manage cultural and charitable institutions, including religious property and funds, of course, all of that under the supreme supervision of the state. It is their obligation to mediate an official communication between state authorities and individual municipalities, and at the request of the Ministry of Justice, give opinions on draft laws and regulations concerning the religious community, and also separation and merging of Jewish municipalities can be done at the request of 20 adult and independent members of the Jewish church. Decision on the establishment, separation, merger, and abolition are made by the Minister of Justice on the proposal of the association, the Jewish Association, and material funds for the needs of certain religious municipalities, the Federation and Association, will be provided with income from property, religious taxes, contributions, gifts, and so on. And the spiritual leaders of religious municipalities are rabbis, and they are the appointed members of municipal boards when resolving religious issues. And now the official language of the Jewish religious communities and their central institutions is the state language. Now something about Catholic Church and the adoption of the Concordat. So the concordance of the Holy See concluded with certain states continued their legal effect within the borders of the territories, which were included in the Kingdom of Serbs, Croats, and Slovenians after the end of the First World War, but as internal state laws without the force of an international agreement. And the Austro-Hungarian Concordat, concluded in Vienna on August 18, 1855, and repealed by decision of Emperor Francis Joseph on July 30th, 1870, was still valid in Croatia. And the complex issue of the organization of the Catholic Church in Bosnia and Herzegovina was defined by the signing of the convention between the Holy See and Austro-Hungary in 1881. Now, the position of the Catholic minority in Montenegro was regulated by the Concordat, which in the original is called an agreement, which was signed in 1886. But after many years of negotiations, the Kingdom of Serbia regulated relations with the Holy See by the Concordat ratified and the session of the Assembly in Niš in 1940 on July 26th. And this law on the Concordat between Serbia and the Holy See in Rome, as full title of the act reads, is relatively short. It contains only 21 articles. And during January 1919, the government of the Kingdom of Serbs, Croats, and Slovenians requested notification to the Vatican, but the recognition was refused with the motivation to wait for the outcome of the negotiations in Versailles. And after the failure of the plans to save Austro-Hungary, which was insisted on by the Vatican, with a note from the Secretary of the State, Cardinal de Gasperi, on November 6, 1919, the Holy See recognized the new state, and with the adoption of the widowed constitutions, the conditions were created for Pope Benedict XV to repeal the Vatican's agreements with the states to which territory the new state belonged before the conference in Versailles by a special statement of November 1921, and after a religious poll with representatives of the Catholic Church in 1921. And by the Bishop of the Church, the state authorities made a decision in 1922 to begin negotiations with the Vatican to conclude the Concordat, and negotiations began in 1925, and the Concordat was signed in Rome on July 25th, 1935 by Judevi Tauer, Minister of Justice and Guardian of the State Seal in the government of Milan Stojadinovic, and Secretary of the State, Eugenia Pacelli, the future Pope Pius the 12th. And the text of the Concordat was not published at the time of the signing, but it covered the following issues. Those were general provisions, ecclesiastical provinces, hierarchy, clergy and monasticism, property position, prayer for the ruler, national minorities, Catholic action, and final provisions. But what's important that the Concordat recognized the Catholic Church's full right to freely and publicly carry out its mission in the kingdom, and respecting the code of canon law, the state recognized the legal capacity of all rights of the Catholic Church and its institutions, and the state authorities were obliged to provide all kinds of assistance to the Catholic Church in order to execute orders, decisions, and judgments issued by the competent church bodies. And issues not regulated by the Concordat, which refer to church persons, would be resolved on the basis of the code of canon law. So those are all the laws on the existing religions and in the Kingdom of Serbian, Serbs, Croats, and Slovenians, and Kingdom of Yugoslavia. And now to conclude, including the parts of Austro-Hungary inhabited by the two constituent peoples of the Roman Catholic faith, as well as Bosnia and Herzegovina, with a large Muslim community, the new state was multi-confessional, which excluded the possibility of establishing a state religion in the Kingdom of Serbia and Montenegro. So in the composition of the new state, the possibility to find new solutions was limited and conditioned the recognition of the full equality of Islam and traditional Protestantism, and agreed and signed in various documents. It began to be forgotten and faded from the moment when the state was constituted, and the fierce political struggles began, which each national group used in order to take a better and stronger political position. Now, the adoption of the law on the Serbian Orthodox Church ended almost 10 years of work, which is marked by the bishop's incompetence and maladaptation of the new social reality, protests of the people unwilling to lose their historical influence on church affairs, and using the position of a stronger negotiating party, the state retained a decisive role in the election of the patriarchs and bishops, provided insight into church finances, established flexible control mechanisms in sectors of religious life that were the subject of joint work. Also, the Muslims, thanks to their numbers, were a real political force that had to be taken into account, but the creation of a single Islamic community was delayed for years, and when it was created, it was placed under the complete control of the state. Now, the adopted legislation on the Islamic religious community enabled the first phase to include individuals willing to engage in the most important organs and bodies in order to achieve the goals of the state policy, while the second priority was given to activities aimed at liberation from established state control, law on evangelical churches and the Reformed Christian Church and the law on the religious community of Jews in the Kingdom of Yugoslavia also largely contained solutions characteristic of the laws on the Serbian Orthodox Church and Islamic religious community. So the complex issue of relations with the Catholic Church and its position in the new state remain unresolved due to unwillingness of the ruling elite and the resistance of Serbian Orthodox Church to complete the ratification of the already signed Concordat, so they can hold up from doing that. But summarizing the above, it can be stated that the basic characteristics of the adopted religious legislation is the common provisions which confirm that religious communities are part of the state system and that the state controls their work, and the enacted constitutions from 1931 specifies that religions can only be recognized by law, so that can resolve the dilemma and confirm the right to legal existence in the Kingdom of Yugoslavia now to the Serbian Orthodox Church, Catholic Church, Islamic religious community, Evangelical Church, Reformed Church, and the Jewish religious community. So to conclude it all, we can say that although the Constituent Assembly accepted the principle of separation between the state and the church, and the principle of state churches was abandoned when Kingdom of Serbs, Croats, and Slovenians was created. The church was dependent on the state, and particularly the king, who elected the Council of Ministers itself, and the Council of Ministers was responsible only to him. And that was all legalized by the enacted constitution. So all the elections of the highest heads of all the existing churches in the state needed to be confirmed by a decree of the king. So it can be said that this period of our history is characterized by religious pluralism and firm religious regulations, but also by the interference of the supreme power in church affairs, as well as the entire domestic policy. So that's it, and thank you.
Thank you very much, Joseph. And now we move on for the last speaker in this session. That is Jan Tranžik from the Masaryk University Faculty of Law, and his paper is Church, Wartime Slovak State, and the Jewish Community in Nitra. Jan, go ahead.
Okay, I'm trying to share my presentation. Does it work?
Yes, we can see it.
Okay, so thank you for the introduction, Nina. And ladies and gentlemen, in this presentation, I am going to talk about the Jewish community in Nitra, mostly in the times of autonomous Slovakia and the Slovak State, in the times before and in the Second World War, from 1938 to 1945. Nitra is a city on the Nitra River in Ponitria region in southern Slovakia. Since the 10th century, it was a home to a Jewish community and the center of Jewish culture and education in the region. In the picture, you can see a Jewish school of Nitra. In the 1930s, the leader of the Jewish community was Rabbi Samuel David Ungar, depicted in the photograph. He was not only the Rabbi of Nitra, but he was also a vice president of an international Jewish organization, Agudat Israel. That means he was quite well known and respected in the international Jewish world. He led a Jewish religious school, or yeshiva, in Nitra, which was quite famous among the Jews of Europe, and had over 300 students from not only Czechoslovakia, but also from the different parts of Europe and even from the United States of America. In 1938, Munich Agreement was signed and Czechoslovakia was forced to hand its territory to Nazi Germany. After this, the Czechoslovakian state was weakened and the Slovak nationalists took this chance to get the autonomy. The nationalism was rising in Slovakia together with anti-Semitism, and in Nitra we know that a few Jewish businesses were vandalized in the last months of 1938. The reactions of the police were like they didn't care very much. On 14th of May 1939, an independent Slovak state was proclaimed. It was a part of Nazi Germany to break Czechoslovakia. The Slovak state was formally independent, but all the time it was more or less a German satellite state. Its political ideology quite uniquely combined Christianity and Christian values with the National Socialism or fascism. In the picture, we can see Josef Tiso, who was the first and only president of the state, and also an active Catholic priest. Tiso was trying to claim that the fascism and Catholicism are perfectly compatible. But most of other Catholics did not agree with this. There are big differences. The Slovak state had a constitution. In the Article 81 of the constitution, right to life, freedom, and ownership of property for all people, regardless of differences based on origin, nationality, religion, or profession, was guaranteed. In practice, it was mostly ignored. Many laws or acts which openly violated the rights of Jewish population based on their religion or even their origin were enacted. Just a few weeks after the Slovak state was created in March, first act which defined Jews on religious basis and banned them from doing certain professions was issued. The Jewish businesses were gradually expropriated from the Jews by the state. Some of them were sold to Christian owners. That is called Arianization, in Slovak Arizácia, or some of them were not sold to Christians but liquidated. So the Jewish owners, Jewish businessmen, would lose their sources of income. Later in 1941, an act called the Jewish Codex was enacted. It didn't define Jews on a religious basis anymore. Instead, it adopted the German classification of people on a racial basis. The Codex banned Jews from many activities, and it was possible to get exemptions from the Codex by an exemption issued by the president. A few hundred exceptions were issued for the Jews who were considered to be somehow useful for the state. In Nitra, there was a population of approximately 5,000 Jews in 1939. On the picture, we can see Párovská Street, which was the hub of the Jewish community in the city. The community owned hundreds of businesses, from little corner shops to big factories. In the process of so-called Arianization, as mentioned before, 269 of them were sold to Aryan owners, and the rest were liquidated. That meant a lot of Nitran Jews lost their sources of income, and the community was pauperized. Jewish children were banned from visiting regular schools, so they had to go to a special elementary school for Jews only, and it existed before, but it had to be expanded to accommodate all of the students. Apart from the Jewish elementary school, the Jewish religious school or yeshiva, which was working in the city before the war, was operating too. And it was quite surprising because it was the only yeshiva in the whole Europe under Nazi control. It was led by Rabbi Samuel David Ungar, together with his son-in-law in the picture. His name was Chaim Michael Dov Weissmandl. From the legal point of view, it was working in a legal vacuum. There was no legal rule which would regard the status of a Jewish religious school, as it was the only institution of its kind. In fact, it was not closed thanks to a secret agreement between the rabbis, namely Weissmandl, the mayor of Nitra, František Mojto, and the Catholic Church, namely the Diocese of Nitra, led by Bishop Karol Kmeďko. who will be mentioned later. In 1942, a German consultant, Dieter Wisliceni, a member of SS, together with Slovak fascists, made a plan of deporting the Slovak Jewry to concentration camps in Poland, occupied by Nazi Germany. As a result, in April, 3,108 people, which was approximately half of the population of Nitra, were deported to concentration camps. Initially, some people hoped they will come back because the official propaganda was saying they are going to work there. But the government did not expect them to come back, and it showed up a few days later when the properties of the deported Jews were being sold in a public auction in Zobor barracks in Nitra. Nobody expected to come back. The Slovak government did not care very much about the legality of these actions. Only in May, a law was passed which allowed the deportations with retrospective effect, which is a clear violation of both the Slovak Constitution and the most elemental principles of law. In summer, more transports of hundreds of people were sent. In total, approximately 3/4 of Nitran Jews were sent to concentration camps. And eventually, in the autumn, the transports were stopped, and it is not exactly known why. The fact is that the Catholic Church protested against the harsh anti-Semitic policies of the Slovak state, especially since Josef Tiso, as a president and a Catholic priest, was seen as a representative of the church. Tiso was only a parish priest in Bánovce nad Bebravou parish. It is a small town near Nitra. And the bishop of Nitra, Karol Kmeďko, in the picture, was Tiso's superordinate in the church hierarchy. It is known that Kmeďko has repeatedly discussed with the president, who had to respect him, because in the church hierarchy, Kmeďko was above him. And it is possible that Kmeďko, bishop of Nitra, has secretly persuaded the president to mitigate the harsh policies against Jews. To explain this, in church law, only a specific sinner can be punished. That means if a Jew is doing something wrong, of course, he can be punished, but not the whole group. The details of Kmeďko's activities are not well known because he was more or less forgotten after the war. He was a Catholic priest, and also he was a supporter of Slovak independence. Not the Slovak state as it existed, but he thought Slovakia should be independent in more democratic form. Both of these beliefs, Catholicism and Slovak independence, were unpopular after the war for the communist government which ruled Czechoslovakia. So Kmeďko was forgotten, and maybe in the archives in Nitra there are some very interesting information about his activities during the war. It is yet to be explored. But there is another factor in stopping the transports, which was probably more important. A rabbi from Nitra Yeshiva, Michael Dov Weissmandl, mentioned before, he was working tirelessly on saving the Slovak Jewry. Together with so-called working group, they bribed the SS man Dmitry Wisliceni, who was responsible for the transports of Slovak Jews to Germany. They gave him 50,000 American dollars, which was a lot of money for that time, in order to change his mind. And after a while, the deportations were indeed stopped for 2 years in October 1942. The non-Jewish people had various stances towards the Jews. Some believed the news, the official propaganda, that the Jews were horrible, but many didn't believe it and secretly helped their neighbors. In the hills north of the city, there were many shelters used by the Jews who needed to hide. In the picture, we can see Emerencia Menyhard, who was awarded the Righteous Among the Nations award by the State of Israel after the war. Her and her husband Julius helped more than 20 people during the war. Julius saved a little Jewish girl named Eva Laszlo in an interesting way. He declared he was her father, although it was not true. And as a child of a Christian, she was not persecuted anymore. In 1944, an armed rebellion against the Slovak fascist government and the Germans, called Slovak National Uprising, started. The German army came to suppress it, and it effectively took control over Slovakia. They completely ignored the exemptions issued to selected Jews by the President Tiso. They ignored Slovak law. They ignored basic principles of humanity. Every Jew who did not hide was either murdered or sent to the concentration camps. Rabbi Weissmandl was sent to the Auschwitz concentration camp too. He managed to escape from the train, but his family was left there, so he was not very happy after that. He survived the war eventually, but he did never come back to Nitra. Instead, he moved to Switzerland and then to United States of America, where he established a Jewish religious school called the Nitra Yeshiva in the memory of the famous religious school which existed in Nitra before the war and even during the war. The yeshiva in Nitra itself was, however, closed after the community of Jews in the city was almost destroyed. Its building was destroyed after the war. Nowadays, there are approximately 50 Jewish people living in the city, and a synagogue is being kept as a monument. As a conclusion, I would like to point out that the community of Nitra was annihilated by acts which did not even follow the constitution of the wartime Slovak state, and it was wrong on every possible level. So that would be all. Thank you for your attention, and I'll be looking forward to any questions.
Thank you very much, Jan. So we are opening the discussion. Are there any questions for any of our speakers? Feel free to either raise your hand in the app, type your question in the chat window, or simply turn your microphone on and start asking a question. There is a question from George Gojkovic in the chat. I'm going to copy it to everyone. So George says, a question for Jan Tanjik: did the position of Jews and their Aryanized property improve during the post-war communist regime?
Slightly, like the Jews were definitely not persecuted. It was not wrong to be born as a Jew, but on the other hand, only a few Jewish people who managed to survive the concentration camps did actually get their properties, which were confiscated by the Slovak state, back. Some did, but they had to ask for it, and even then it was not sure that they will get it.
Thank you. Any more questions?
May I ask something?
Absolutely, Milos.
Thank you. Well, I will not address to anyone specially, but I'll try to reconsider something what was, of course, a part of some of my researches. And if anyone is interested, I will welcome a potential answer. I think that some of Nazi Germany's programs, especially Lebensborn program, and the program of establishing of special schools, which were looking like agelas in ancient Sparta, were specifically rooted in ancient Sparta regime and kind of state program which considered making of better people of course, in scopes of eugenics programs. Sometimes even Adolf Hitler himself, of course, in a weird way, stated that one can say that Germans are somehow, or Spartans are ancestors of Germans. They have even similar food, which they ate commonly, some kind of beans, etc., etc. I'm not sure how did he come to that conclusion, but that is the point, in fact, knowing that they established schools in which they prepared young Germans for some kind of inclusion in political life, in education and in preparation for participating in Nazi regime. Did someone notice maybe some common roots or some resemblances with the ancient Sparta, principles? I apologize for these voices around. My son is here and he's very interested in what we are talking right now, but he's a little bit mad because he does not understand right now what we are talking about. It's a strange language for him. So I will not be any more extensive. So if anyone is interested, we may discuss about what I ask. Thank you once again.
Thank you, Milos. No problem for the sounds. I get those too. Since it wasn't addressed to anyone in particular, does anyone have any observations, comments, any response to what Milos said? We will have Tamara's presentation about eugenics in Germany later today, but that will be in Serbian.
If I may interfere once again, maybe the principal difference between German eugenics and Spartan eugenics was the aim. In fact, Spartans, I believe, they try to make a better people, hoping that making better people, better individuals, may consider to make a better society in a whole. And I think that the Germans, on the other hand, tried to exterminate some social groups which they considered are not so worth, if I may say, of living or participating in some kind of community they intended to create. There is as well a comparison with some modern eugenics principles and methods, which are widespread all around the world nowadays. And I think that there is another difference. I mean, today we are witnesses that all eugenics or some kind of new eugenics principles are introduced in order to fulfill the needs of individuals. But in ancient Sparta or in ancient societies, not only in Sparta, of course, they intended to proclaim and to introduce and to defend such rules in order to make better society in a whole. Of course, both approaches are wrong completely. We are aware of that, but maybe the aims and the intentions are different nowadays in comparison with what had in history.
Yes, you're right, of course. I mean, if we look at one thing, at something that we would find completely cruel from a modern point of view, the practice of killing or abandoning weak or sick babies that was present not only in Sparta, but in many ancient societies. It was there as a measure to ensure the survival of the community because they can't afford to spend their resources on individuals who maybe won't survive to adulthood or who will be incapacitated and needed to be taken care of all their lives. And today, on the one hand, that practice is reversed, but on the other hand, we still have, in those countries, we do have, for example, abortions for medical reasons when there are medical indications that there will be something seriously wrong with the child. And we'll also have an interesting presentation from Arina in the next session regarding that. So does anyone else have any questions or comments? If not, maybe we could take a break now. We are slightly late, still behind schedule, but unless someone is very much in a hurry, maybe we could take a 15-minute break now, since the last one was shortened, so we could have a slightly bigger rest for our legs and for our ears. And then in 15 minutes at 1:30 round, we will continue with the next session. I thank all the speakers of this session once again and see you all in 15 minutes.